Hello, hello, hello. Good day. How are you doing? How is life? Hope you're good. Hope you're fine. Welcome to Lawyers Info Hub. This is a platform where we share legal tips for law students, for lawyers. We are poised in making them become better in whatever they're doing. We are contributing our quota to the growth of legal education in Nigeria and beyond. So you're welcome. So today we're looking at Garnishee Proceedings in Nigeria. Garnishee Proceedings. Many lawyers have know about Garnishee Proceedings, but they've never had course to go through that route. Garnishee Proceedings is one of the ways money judgments are being executed. Literally, it is one of the ways a person who got judgment in his favor and is a money judgment can use to recover the money in the judgment. That is the literal definition of Garnishee proceedings. Is one of the ways you can use one of the ways of the procedures to recover money in a money judgment. Now the court has given judgment and involves money, is a money judgment, and you want to recover your money. So we can use the Garnishee proceedings to recover your money to get back the money from the judgment debtor, who is the person, you know, the judgment is against and who the court has ordered to pay you so your the amount owed you. So principally, Garnishee proceedings are governed by a set of legal framework. There are laws in Nigeria that govern Garnishee proceedings. Now, the first one is the Sheriff and Civil Process Act. The Sheriff and Civil Process Act is one of the principal legislations that govern Garnishee proceedings. So when you want to um, Garnishee proceeding process, you want to, file your processes, you must be abreast with the Sheriff and Civil Process Act. What does the law say and how it is said and how the laws are provided for what to do and what to be done. The second one is the judgment and enforcement rules. These rules is like a handmaid of Sheriff and Civil Process Act. They work together, you know. So it's also one of the rules you can use in your Garnishee proceedings. You have the High Court rules of various states. Each state have their High Court rules, and many, in by way of amendment, have incorporated Garnishee proceedings in the rules, whereby some states do not even have Garnishee proceedings in the rules. So we rely on the Sheriff and Civil Process Act and the judgment enforcement rules. We have the Federal High Court Civil Procedural Rules, to which make provisions for Garnishee proceedings. We have the National Industrial Court rules too. So these court rules also makes room for Garnishee proceedings. But where, for example, if you're in a just like I earlier said, in a state high court, your state high court does not make provisions for that. You can rely on the two principal ones I've already stated, the Sheriff and Civil Process Act and the Judgment Enforcement Rules. Now, of all the courts in Nigeria, the National Industrial Court is one court that has an elaborate, comprehensive procedure on Garnishee proceedings. Amazing, amazing, amazing. So we also hope that other courts will join them in having a very robust, comprehensive proceedings or outline rules for Garnishee proceedings. Now, the Sheriff and Civil Process Act, as much as it makes provision for appointment of sheriffs, allocation of duties of sheriffs, the enforcement of judgment, other service, execution of civil processes, and in court, it's made up of 112 sections, with section 1983 to 92 dealing with Garnishee proceedings. On section 1983 to 92, basically deals with Garnishee proceedings. So section 19 just deals with interpretation of words, phrases, judgment creditor, judgment debtor. Section 83, this is about the jurisdiction of the court to the Garnishee matter. You know, also makes provision that at least 14 days before the hearing, a copy of the Garnishee order should be served on the Garnishee and the judgment debtor. Now, in Garnishee proceedings, we have the judgment creditor. That is a person in whose favor the judgment is. The person who is being owed. Yeah, we have the judgment debtor, the person who is owing. We have the Garnishee. Garnishee in this instance, the banks where this person, the judgment debtor is assumed to be having money. So as a third party, you can issue the banks, okay, make known the amount of sums of money in the account of this person who is owing. And you must know that before we talk about Garnishee proceedings, there must be the judgment of the court. So section 84 now also talks where that where money that is supposed to be that is liable to be attached by Garnishee proceedings in the custody or control of a public officer in his official capacity, that the court should not order make an order for to order nicer or attaching such money unless there's a consent of the Attorney General. That is under Section 84 of the Sheriff and Civil Process Act. We have the Section 85. I'm just reading out this section so that when you go back, you read them and understand what each section is talking about. Section 85 talks about service of the Garnishee court order. Once the court makes the order nicer, that it has to be served, on the Garnishee and on the government debtor. So that's what Section 85, talks about. Section 86, if the Garnishee is does not within the prescribed time pay into the court the amount due, together with the cost of the Garnishee and does not dispute the judgment debt which is due, that the court, upon being satisfied that service of the order nicer was served on the judgment debtor, can proceed to make an order that such money, be paid by the Garnishee. That is, that the Garnishee who is holding the money for the judgment debtor should pay the judgment creditor the money that the court has ordered in the judgment. Now, Section 87 of the Sheriff and Civil Process Act talks about where the judgment debtor disputes the the money, that's the judgment debt, where he disputes it, when he denies liability, what can be done upon such, whether such denial can be resolved by affidavit evidence or by oral evidence. That where the court is not satisfied with the affidavit evidence, court can make an order for oral representation to be like in a trial form where the judgment debtor is saying, I'm not owing this person. So court will make a room even after judgment, and that the affidavit evidence filed by property is not really clear. The court can make an order for that judgment debtor to come to court and be cross and questioned as to this is denial. Now section 88 talks about where this judgment sum, to be attached belongs to a third party. So that's what section 84, 88 talks about, and other things. Um, Section 89 talks about where service of the other side has been, there's evidence of service, and this same the third party refuses to appear as commanded by the court. That is, the judgment debtor, once there is proof on him that or on it, depending on who a person or a juristic person, and refuses to appear, what the court can do. Now, the court has the power to proceed for the fact it has shown that they were served and there was no representation. The court can proceed. Section 90 talks about appearance of third party, as it says in section 88. Where there's a third party is coming to say, see, this money to be attached belongs to me. The court can give room for the person to be heard. Section for section 90. Section 91, where it's about discharge of a Garnishee, where a bank comes and said the money in favor of the judgment debtor in our custody is so amount. We are willing, by filing the affidavit to show cause, that we are willing to let go, surrender this money to whoever the court makes an order in that respect, or to the judgment creditor based on the Garnishee proceedings. So that order of discharging the Garnishee from the proceedings is under section 91. So go when you read these sections, you have more understanding of what we're all talking about. Now, Section 92 now makes proof the Act provides that once the money in the account of the judgment debtor has been attached by an order of court, any payment made from such account to the judgment court during the continuance of that proceeding without the leave of the court shall be null and void. What Section 92 is saying is that once another absolute has been entered concerning the money in that judgment debtor's account with the bank, and the Garnishee, which is the bank now, is aware that the court has made an order absolute over that money and goes ahead to pay the judgment debtor money from that money in the custody of the bank without the leave of court. So that payment is null and void because the bank will be held responsible for that. And, so just these sections are the section from section 1983, to 92. Yeah. They all deal with Garnishee proceedings. Talks about Garnishee proceedings. So we'll be able to look at them. Yeah, section 1983 to 92. So go back, look at them, read them, understand them. Because if you're going to go through or handle Garnishee proceedings and you don't know these sections, it may not be good for you. Yes. So we talked about the judgment enforcement rules. And I told you that the judgment enforcement is like the handmaid. They are kin, they work together uh, to the Sheriff and Civil Process Act. So the judgment enforcement rules is in the indispensable handmaid. They work together. For the rules is in orders, not sections. Why the Sheriff and Civil Process Act, you have section this, section that. In judgment enforcement rules, you have order this, order that. Now, in judgment enforcement rule, it is made up of 12 orders. They're arranged in Roman figures. They're made up of 12 orders. Now, specifically, order 8 is the order that deals on Garnishee proceedings. Order 8. Now, under that order 8, we have order 8 rule 1 to 12. Order 8 deal of the judgment and enforcement will deal with Garnishee proceedings. Then order 8 rule 1 to 12 are the sub rules dealing on Garnishee proceedings. So when you talk about order 8 of the judgment and enforcement rules, it's about Garnishee proceedings, and that order has 12 rules under it. So talk about how the process to. So when you read it together with the Sheriff and Civil Process Act, you have a better understanding of what Garnishee proceedings is. For example, if you are for the judgment creditor, or you are for the Garnishee, or you are for the judgment debtor, how do I come in? How do I proceed? What do I file? What is important? Where peradventure you want to take out a preliminary objection, what are the things I can base my preliminary objection on? That judgment and judgment enforcement rules. Rule 10 also talks about cost. Rule 11 makes provision that the magistrate or a judge may, in their discretion, refuse to make or issue a Garnishee order, where, for example, where the judgment sum is a very small amount, and the cost of even filing the suit, serving the Garnishee, and all of that is so much. The court will look at it and like, if amount is too small compared to the cost you will spend in even bringing these people to show cause, then the court may refuse and see that it is not reasonable. It is worthless, it's not vicious, it's not really in line. Why would you want to spend so much to even get a immediate amount? So the court, these are the things the court looks at using its discretion. Now, I earlier told you about high court rules. So the various high court rules, they have made provisions for Garnishee proceedings, though states have a robust rule like the National Industrial Court, where I told you that they have very, 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 very robust rule on Garnishee proceedings. Now, it's also very important for you to note that as a counsel for the judgment creditor applicant, now you can choose to rely on the Sheriff and Civil Process Act in your application for Garnishee order, or you can also rely on the provision of the rules of court, depending. You can also combine the both. You can make your motion can be together. You can bring it under the rules of the Sheriff and Civil Process Act and the rules of the court, or you can also join the judgment enforcement rule to bring your application. You must also note that Garnishee proceedings are very contentious. We're talking about money. The judgment debtor will be fighting, so you must be abreast with the rules. What is the rules saying? What are the legislations saying? What can be done here? What cannot be done? When you are, involved with beyond getting the judgment, now the judgment has been gotten, the client is saying, lawyer, how do I get my money? And you want to do Garnishee, you must understand it. If you don't know it, meet people who have experiences in this. They will guide you through what to be done and how to go around it, because it is time bound when to serve, and if you serve beyond that or above, what can be, whether there are penalties. So these are the things they'll put you through. So also your read your rules very well. Now, also there are things as a counsel you must understand. Now that every Garnishee proceeding must be founded on a judgment of a court of law. It is not competent, the Garnishee proceeding is not competent if it is not a judgment that is pronouncing on the death. So a Garnishee proceedings, it must be predicated on a judgment of a court. Now, it's also very important to know that when the judge has made this judgment, the judgment creditor can then make an application, ex parte, and ask that the court grant it, make another order nice high, so that it can serve the order on the judgment debtor and the Garnishees, asking them to show cause why the money or the judgment sum should, the court should not make an order absolute on the judgment sum that is due. Now, you have to also understand that where the first process you file is a motion ex parte, not on notice, it is that upon the granting of that motion, the court will now make an order nice. That is the first step. You file your motion ex parte, asking the court to make an order nice, so which will be served on the parties, both the judgment debtor and the Garnishees. In the Garnishee proceeding, must understand that the Garnishee must be resident within the state where you want to carry out the Garnishee proceedings. It is a requirement of the law that the Garnishee must be resident within the state in which the application for Garnishee order is being made. If the Garnishee must be within the jurisdiction of the court. It's very, very important. Very, very, very important. Check out the case of Central Bank of Nigeria against Auto Import Export. It's a 2013 Nigerian Weekly Law Report, part 1337 at 8. Also check out the case of Central Bank against Okabe Nigeria Limited. It's a 2014 electronic law pavilion electronic law report 23162, paragraph 26 to 27, where the court made a disposition on the mandatory requirement of the law that the Garnishee must be resident in the state in which the Garnishee orders is to be made. So there are also other cases you can look out for. Have Dasi Digital Press Limited against Ademola Ayo. It's a 2018 Law Pavilion Electronic Law Report 4448. It is a Court of Appeal decision. So this, you must understand, is the fact that there must be a judgment upon which the Garnishee proceeding will be predicated. The Garnishee must be resident in their state wherein the Garnishee proceeding wants to go on or will be handled, must be resident there. Now, as counsel, you must be very vigilant. When you have served a Garnishee Proceeding application, you have to look at it very well. Does he does it have anything that is not supposed to have? Um, Look at things. Okay, if I want to raise an opinion objection, what are the lapses? What are the vacuums or the lacunas? So that is what you have to. So when you have been served a Garnishee Proceeding, you study it very well to look at it. Is it proper? Is it right? So when as for So as a judgment creditor, you must ensure that the garnishee against whom the application for the expert is made is a person or institution that is resident within the state where the court is what located. You must also understand that when you critically look at the process you are being served with, you check out the jurisdiction of or the place of residence of the garnishee and the judgment debtor. You look like where is their location? These are things you have to look out. Now, if the court is not within that jurisdiction, you have to prepare a notice of criminal objection to take out a criminal objection to, you know, object to the jurisdiction, want of jurisdiction, where the court is not within the jurisdiction. So it's very, 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 very key. Very, 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 very key. Now, even if when you take out a criminal objection and the court still proceeds, you can appeal it. Yes, because jurisdiction is key in everything. Jurisdiction is key in everything. So there are a lot of people that have gone for and against this issue of jurisdiction. You know, when the court said not to have jurisdiction in Garnishee proceedings, and when the court is said to have, there are a lot of cases for and against. So when you get your order nihil, which is the first application based on the motion ex parte, and the court makes an order that within so return date, the garnishee should show cause and the judgment debtor. So you have to serve that order the court made on the garnishee and on the judgment debtor. Now, all the banks will then, if you serve on all the banks you feel the judgment debtor has accounts with, the judgment debtor, those banks will now search their records upon receiving the order of court. When they search their record and they see that there's a name, this particular person has so amount of money in the account, then they will now file what they call affidavit to show cause. When they file the affidavit to show cause, they will state this person has account number, so. He has in account 150,000, or he has in his account 200,000 or 1 million naira. They will now attach the evidence of that amount they have stated as an exhibit to the affidavit to show cause. Now, if it's another bank B say we have searched our record, there are 3 names that have the same similar names to this person. So can you please clarify us by furnish us with more particulars? So it happens all the time. So when the banks request for that, now the judgment creditor counsel will now furnish, maybe if you have the judgment debtor's full details or any other, if you have ID or something to show, or this is his third name. So when you file you do a further um, or a counter affidavit, or you can furnish particulars to the lawyer for the bank. Now the bank will now look at it and say, okay, we've been able to say this is the person and this is how much the account. So people might say, okay, there is no money in the account. Other banks might say, we do not have such a person's record in our bank. So on the return date, the court will look at all the garnishees. When they enter appearance, each of them will, stand up and address the court. I'm the fourth garnishee, I'm the fifth garnishee, I'm the sixth garnishee. The judgment debtor has so amount of money in our credit, and we can order the court to grant, make the order nicer absolute over that particular amount. When all of them have stated what they have, in the what is in the affidavit to show court, the court will now make order absolute over those that have money. And for those that do not have money, they'll be discharged. For those that have money, order absolute will be made against those money. Against the money, then court will also discharge them. Upon that, the bank will now, transfer the money to the judgment creditor. So if you're a counsel to the judgment creditor, upon getting the order of court that has, made the order nicer absolute over those sums of money, you will write to the banks and say consequent with attaching your CTC of the order of court. Consequent upon the order of court made to so they please do credit the judgment creditor's account. You state the account of your client so that the bank can see where they will transfer the money. No bank has the right to withhold any money that the court has entered the order of salute on. So they are willing to always let go of it and they'll pay the judgment creditor. And on the next date, the judgment creditor will be able to say, okay, my lord, we have received so for 4 banks. You have been paid, even though the money is not enough, or the money is enough, and that will be the end of the proceeding. But where the money is not enough, after all the banks have come to say this is the money in our account, then the court will say, okay, what else do you want to do? Sometimes, in some instances, it's okay for those that are having issues of further particulars. Let me furnish them with the further particulars. You know, and where, for instance, the there are instances where maybe the judgment debtor is so too sure that the judgment debtor has accounts in a particular bank, and that bank comes to say there is no money. Sometimes there will be a counter affidavit when the judgment creditor filed a counter affidavit to the affidavit of that particular garnishee of the bank. Then the court might need to address it and say, okay, make further search into your data and bring up, or the court might make an order, or depending on the way parties argue, parties of the bring further, go and make further search. Or if this other party is too sure of his assertion, you attach exhibits to your counter to show that as at so time, the judgment debtor had so amount of money. And it's also important that once you serve the other NISAN on the bank will, once they have received it, no money will leave that account. If actually there is account in that bank, that is how it works. No money leaves the account. And where you can prove that money left the account, you can prove that money left it, and if they will print the statement of account. If you are smart enough to see that money left the account after the order was served, you see that the bank will go in for it. So when you're doing Garnishee proceedings, your eyes have to be down, you must be articulate, you must understand what you're doing. Because sometimes the judgment debtor will come and be filing loads and loads of processes. No, you know how to address it. So Garnishee proceedings are quite kind of complex sometimes, but you must be abreast with the law, the legislation, what the rules provide for, what the act provide for to tackle it. Then if at the end of the day you're able, sometimes some people are very lucky at the end of the Garnishee proceeding, they will have the amount of money that is in the judgment debt, whereby some they will have less. So they will take what they get and move on to the next way of enforcing the judgment. Whereby if the money is complete, they will, that will be the end of the Garnishee proceedings, and they take what they have, they have gotten. So it's either way, it can end differently. So Garnishee proceedings is one of the easiest way people, use to enforce money judgment. So you must understand the intricacies. So I just hope you've been able to learn something today in today's class about Garnishee proceedings in Nigeria, the legislative framework, how to go about it. So friends, if you're not subscribed to this channel, do hit the subscribe button, share this video, drop your comments, let me hear what you have, questions, contribution, just drop them on the comment section, and do click on the like button. Do take care of yourself.